in the simple place where you have to acknowledge that the law doesn't support what position you would like to take, and you abandon it.
Right.
Rarely have I seen situations where you have a conflict in authorities that are comparable or equal.
Right.
We don't get the Supreme Court of Canada saying two things at
Right.
the same time. We get conflicts, certainly, in the appellate courts. But my experience with the law is that if there's a conflict, there's a reason for it. So there's room
Right.
for the advocate to be creative,
Right.
because the judges are in disagreement
Right.
on what the law either is or ought to be. I think that here again, it raises an issue of time and time management. I usually, when I'm in those kinds of situations, will file a written argument.
Right.
Now, that depends on the case, of course. If it's a half-day, low-complexity trial
Right.
in provincial court in a 3-witness assault case, one may not prepare a written argument. One will bring the cases
Right.
and be prepared an oral argument.
Right.
But in a longer case where evidence is maybe more lengthy and somewhat more complex, a written brief is very helpful. And I don't think any judge would say they don't appreciate it, particularly in a situation that we're talking about,
Right.
where there's a conflict in the law or the authorities.
Right. Right. Now let's take another, again, dealing with the role of the advocate in code of professional conduct. Now, what I think I've heard you say is that when there's a conflict, when there's contrary authority, you tell the judge, right? The judge has every right to expect that that he has a right to an impartial view of what the law is. This is what I think about it. I prefer this version, but there is this case out there, right? Which I think maybe people in law school might be surprised by, or maybe they wouldn't be, I don't know. But let's take a slightly different one. Let's take an issue of fact. Let's say, for example, that the client has said something to you, I didn't do it, okay, I'm not guilty, okay? But you personally find it implausible. Okay, you aren't persuaded by that. You probably agree, and I think many of the senior lawyers would know the answer to this. But again, some of the junior lawyers, they may not know how you deal with that. What would your advice be, or what's the correct way of dealing with that scenario?
Do you mean in a situation where the client wants to testify?
Well, let's go through the different situations then, right? I mean, generally, you've got a guy. You're not really buying what he's saying, but he's pretty clear that he didn't do it. What about when he it's probably less of a problem when he doesn't want to testify. When he does want to testify, how would you deal with that? What are your thoughts on it?
Well, let's take a hypothetical that's, I think, what you're getting at.
Sure.
The client denies
Sure.
that he did it. And the evidence produced by the Crown in its case is credible, and in counsel's assessment, reliable.
Right.
And there is, however, an argument with respect to interpretation,
Right.
maybe, of aspects of the evidence that may raise a doubt, or it leads into a legal argument on an element of the offense that may result in an acquittal.
Right.
I invariably will sit down with the client and map it out.
Right.
And give the client my advice that he testify or not testify.
Right.
Rarely have I had a client disagree
Right.
with what my advice is.
Right.
When I explain why
Right.
the advice is being given.
Right.
One has to be careful because it's the client's right to testify. But I think most people will listen to their lawyers, and sometimes individuals and any human beings prone to this, we get so emotionally wrapped up in the fray of the courtroom, we lose sight of the larger picture, and that's why accused people have counsel.
Right.
So I think the answer to the question from my own point of view is clients are almost always open to reasonable persuasion
Right.
as to what is in their best interests.
Right.
By and large, I can't quantify it by way of statistic, but in most of the cases in my career, clients have not testified.
Right.
And I think in the later years, I have tended to call the client to testify more than I did historically, but that just may be because of the nature of the cases.
Right. Your practice changes.
Is it practice changes, the law changes somewhat, and of course it depends on what the case is.
Right.
You'd often hear lawyers say, well, if it's self-defense, it's the kind of case where the client probably is going to have to testify because he's going to have to testify about his reasonable apprehension.
Right. Right.
In order to ground the self-defense.
And you'd agree with that, I take it? Or you would not?
It's a valid observation.
Right.
But
and it's not an area I'm strong on. So
Yeah.
I mean, what are your thoughts on that?
Well, it depends, of course, again on the case. If there's been a statement to the police and it's been admitted in evidence,
Right.
and what the client told the police
Right.
reveals the reasonable apprehension, and that is corroborated by other evidence in the Crown's case,
Right.
why call him to testify?
Right.
It's already before the
Right.
court.
Right.
And I've certainly had that circumstance arise. So every case is different.
Right.
And I know that there are general approaches and generalities, but they are generalities.
Right.
And we always have to look at the evidence in the specific case.
Right. Now, without going into any specific file, of course, one of the things that you're known for many things in Calgary, but one of the things you're known for is these larger files, or you've definitely had, there's not very many of them, but there are these sort of super files. Now, obviously, you can't go into anything with respect to the actual file, but if a lawyer finds themselves on one of these massive gangs and gun files, or something that's clearly a very large amount of accused, or very, very thing like that, what kind of advice or special challenges do you think, very broadly, without talking about any specific file, do you think you would give to those lawyers?
We've tended to use the term mega trial
yeah, sure.
to describe what you're driving at.
Yeah.
And they often can be drug charges, sometimes they're homicides, sometimes they're accompanied by criminal organization
Right.
charges.
Right.
The average length of one of these cases, in my experience, in the courtroom is 18 months to 2
Right.
years.
Yeah.
That includes pretrial motions and the trial. Sometimes the trial is longer than the motions period, sometimes the reverse.
Right.
Generally speaking, the pretrial motions tend to be the most time-consuming part of these cases, particularly if the evidence involves a wiretap component.
Right. Another one of your specialties, something you're very well known for.
Yes, I do quite a bit of wiretap work.
Right.
And the last one that I completed, the motions and the trial took approximately a year. So that would be at the lower
Right.
end. And my advice to young lawyers is that if you have an interest in this area, then there's no better time than the present to get involved, because unless you get into one of these cases and work, maybe as second counsel
Right,
or junior
right,
counsel
right.
on them, unless you get in, it's impossible to then appreciate
Right, yeah.
the magnitude of these
I
cases.
personally, I do, my practice is very focused, right? But on the other hand, I've been doing this for quite a while, but I would be incredibly hesitant to jump into something like that. I mean, and I'm relatively senior, but I just couldn't imagine, like, so specialized, right? Now, you were actually using the phrase wiretap, and of course, I know broadly what a wiretap is and what a search warrant is, but keep in mind, we're also maybe hoping that some law students might like to look at that. Very broadly, how would you describe, and I definitely don't expect a long dissertation on this at all, because I know you can talk for an extensive period of time on this, and I know that you're incredible. I mean, like Clayton, for the reader or for the listener that doesn't know this, Clayton gives lectures to lawyers on his issues, a very, very detailed area of the law. But broadly, what is the process for getting a search warrant, and what is an ITO, and what very, very overview, what are those things and how does that work?
There are various investigative tools that fall into the general area of search and seizure. These tools are available to law enforcement for the purpose of searching for and seizing evidence. Very broadly speaking, they fall into the categories of general warrants in the criminal code, search warrants in the criminal code,